Okay, from our last video, we left off the section, we're in section B of chapter 2, and we're at number 2, limiting the scope of the treatment relationship. The first case here is Tunkl. Okay, it's Tunkl versus the Regents of the University of California. And what happened here is Tunkl is the plaintiff. Tunkl is the administrator for his decedent who had gone to the defendant hospital, UCLA, was in great pain, under sedation, and was asked to sign a waiver releasing the hospital from any liability claims, medical malpractice liability claims, as long as the hospital had used due care in hiring their employees. So when the patient is at the hospital, he is injured by the malpractice of a physician there and ultimately dies. And now Tunkl, his administrator for his estate, is suing the defendant hospital. Now, the trial court says, finds in favor of the hospital. Okay. It's gone now to the California Supreme Court, and the California Supreme Court says the issue is a medical malpractice waiver valid? And they say no, that waiver is against public policy, and they said we looked at the public interest. Is the service in the public's interest? Is there a bargaining power disparity between the hospital and the patient, which there clearly was. The patient was in pain, under sedation. Is the signee under the control of the other party? Pretty close. They're at his, the patient was at the hospital's mercy. And so he signed it. Okay. And the court says, well, first let's go look at what the hospital said. The hospital made the argument that they are a nonprofit provider, they are engaged in charity, they do valuable research work. It would be very difficult for them to stay open if they are constantly subjected to medical malpractice cases. They say, they argue it's better to allow the waiver so that they can keep their doors open. Okay, well, the court doesn't buy that argument. They first cite Civil Code Section 1668 and that says a contract purporting to exculpate a party from his own negligence will not stand if it involves public interest, which is clearly the case under these facts. Okay, and the court says that a provider can't waive basic ethical requirements in order to do a better job for some or some of the time. They said there's no additional cost to the hospital if they invalidate the waiver. The court invalidates the waiver, so long as they are providing basic non-negligent care. Okay, and the medical malpractice burden is on the patient anyway, and the bar is pretty high. Many tort reform proponents would try to argue that, that tort cases, medical malpractice cases are out of control, that the rewards or the awards, are too high. But really and truly, the ability to prove a medical malpractice claim is a lot higher than we think, and not as many cases are as won as tort reformers would like us to believe. Okay, so But you have to be careful. You can't simply believe that any type of waiver would be void, because there are some acceptable waivers that exist. And we're going to talk about those in just a minute. So, the question is, can this hospital waive medical malpractice liability? And the court says no. Well, how does that apply to a doctor? Well, a doctor can never get a waiver for that liability. Okay? But once again, there are exceptions to this case, to Tunkl. If a patient leaves the hospital against medical advice, of course they're going to be asked to sign a waiver, and those are acceptable. The court says those are acceptable. That's a choice the patient is making. The law doesn't force a hospital to keep a patient who refuses to pay. If there's a waiver for experimental treatment, that will be enforced. But it doesn't waive negligence. All it says is that if you are involved in experimental treatment and have a bad outcome, as long as there was no negligence, the hospital can't be held liable for that bad outcome. Also, it exempt are waivers that arise after settlement. Okay, or partial waivers for arbitration. Okay, so that kind of brings up this question of whether or not, could there come a time when patients could sign a waiver that reduces the liability or the standard of liability in exchange for a discount on medical services. Think about that. Think about whether or not you could negotiate to lower basically the standard of care that the provider has to give in exchange for a lower price. Would the provider know who signed those waivers of liability, and would it change how they treated one patient to the next? So those are some questions I want you to think about. Think about whether or not those, we could get to a point as a way to reduce medical expenses. So the next case that comes up, we move into a section about terminating the treatment relationship. Okay? And the first case there is Ricks v. Budge. In this particular case, we had a patient who is been treated by this group of physicians. He was released. He goes back. They say they refused to treat him because his account's past due. He ends up going to another facility. He gets treated, but eventually loses part of his hand to an amputation. The patient then sues this doctor's group. Looks like it's two related physicians, and the trial court gives a directed verdict in favor of the physicians, and now the patient has appealed. So the court says the issue is, may a physician unilaterally cease treating a patient due to lack of payment? And the court says no, you can't just unilaterally cease treatment. If you've undertaken to treat a patient, you have to continue to care for that patient until such time as the care is no longer required. yes, a physician can withdraw from care, but he has to make sure he's given adequate notice for the patient to acquire alternative care. Okay? And so the court says this evidence should have gone to the jury as to whether or not, they gave him sufficient time to seek alternative care. So while they are not saying that necessarily Ricks is going to win, they're saying it needs to go back. It shouldn't have been a directed verdict. The jury should have had the opportunity to determine, was there sufficient time. So the court says that you got to give them appropriate time, reasonable notice to acquire other medical attention. And the relationship between the provider and the patient terminates when that particular spell of illness ends. Okay, so the relationship continues until the cessation of necessity, which gave rise to the relationship. Okay. Now, that doesn't mean that the patient can't discharge the doctor at any time, and they can do that explicitly or implicitly. They can say, I'm out of here, or they can just not show up ever again. All right? So what the court's saying here is liability is not going to be imposed on a provider for the quality of their reason for terminating, but whether or not they followed the procedure of giving adequate notice. So, I can, if you don't pay, I can terminate our relationship, but I got to give you time to find a new doctor. And this is what we call abandonment liability. It's different from malpractice. If a physician or a provider does not give adequate notice for the patient to obtain other care, then they're subjecting themselves to abandonment liability. Not necessarily malpractice, but abandonment liability, which is more like breach of contract than medical malpractice. Okay? Now, what about hospitals? Well, private hospitals can turn away whoever they want. We've already talked about that. But if that hospital has unique or scarce medical resources that are needed to preserve life, and it's a nature of a public service enterprise, then they can't withhold the services arbitrarily or without reasonable cause. Okay. Now, the last case in this section is Payton v. Weaver. In this particular case, we have a situation where the plaintiff, Payton, required dialysis, and she had gone to Weaver, the defendant physician, but she caused chaos when she came, if she showed up for her treatment. She was supposed to be there multiple times during the week. She would miss appointments when she was there. She would be disruptive. She continued to use drugs and alcohol. She didn't follow the dietary restrictions the doctor gave. So the doctor sent her a letter saying they were going to cease treating her. Well, she filed an action to force the doctor and hospital to provide her dialysis. They met and negotiated a settlement where if she agreed to certain things, they would continue to treat her, meaning come to her appointments on time, behave when she got there, follow dietary restrictions, not use drugs and alcohol. And for a little bit, everything went okay, but then a year later, they're right back where they were, and the doctor sends another letter saying, going to terminate service, and she tries again She tries to force the hospital, force the physician to give her the dialysis. And the court then says, you know what, the plaintiff violated all of the conditions that she accepted in that stipulated order from the year before, and her behavior was knowing and intentional. And, you know, it's like I've said to many of my students, you know, we all want to claim certain constitutional rights, but when your rights begin to affect someone else's, then your rights are not going to take precedent over someone else. So it had gotten to the point where other patients were suffering because of her behavior, and so the court said, nope, we're not going to force that physician. They're under no legal obligation to continue to provide treatment. She appealed, and the court said, no, we're supporting that decision. So yes, the physician has to give due notice, but in this particular situation, this patient had ample opportunity to secure other treatment, and that the defendant physician had even attempted to try to help her. So he's not going to be held liable. So that was the outcome of this particular case. All right, this video will stop here, and we'll pick up next with regulating the treatment relationship.